Yes, your lordships. My lord, item 21 and 39, my lord. I have some personal difficulty which may kindly be taken in the next week, my lord.
Okay.
And I have
20
another prayer also.
21.
21 and 39.
Thirty-one is a 39 is a review petition.
Yes.
We'll try to take it up. The review petitions, we are trying to take it up.
I have some difficulty, my lord. Personally, next week, when I am ready, any day in the next week.
Okay. 39 also. Also, it's a represented on the prayer made by Mr. M.U. Mahmood and counsel for the petitioner. List after a week.
And my lord, item 47, my lord, supplementary. I have some urgency in this matter, my lord. It may kindly be upgraded, my lord, if possible. 47. Sophia Khatun, either upgraded or at 2 p.m. as your lordship's desire.
Okay, we are taking up orders matters first, then we'll take it up. So 2 o'clock.
Yeah, highly appreciated.
May I please, your lordship? My lord, I beg to mention item number 40.
40.
40, lordships. Any other day, lordship. Today some
This
difficulty,
is
lordship.
review matter again.
Yes, lordship, review.
Okay. Same order on the prayer made by Mr. F.U. Barbuya. Okay.
Obliged.
May please, your lordship. Item number 241, part 2 list, lordship. That may be upgraded and that may be taken up on Tuesday next.
We are not upgrading part 2 because those records are not there. Only when we finish up part 1, then only that those come. So you'll have to, so very, because it is from this part 2 list that matters are coming for hearing. So you'll have to move the registry if you want an upgraded listing.
And registry asked me to.
No, because you see the new system which we are adopting right now is that it is from the part 2 list that the matters are coming in part 1, so that you are having an advance information. So that's why. Not this time. Let us see. That reaches.
May please, your lordships, the item number 1, adjourn for day, lordship. Record was called for record receipt, lordship.
1. It goes for a week. Same order on the prayer made by Mr. N. Ahmed, counsel of the petitioner. Okay.
Diploma.
May it please, lordship, I beg to mention item number 38. I adjourn this matter for the day, lordship.
38 is again a review matter.
Yes, lordship. For the day, lordship.
It goes for a week, but review matters we are not will not be inclined. Okay, same order. Your name?
Bidas on behalf of A.M. Ahmed.
Miss Edas.
Idas.
Edas.
Idas.
Item 38.
Okay. May I please, your lordship? Lordship, I beg to mention for listing a method.
Give it to the court master.
May I please, your lordship? Lordship, I beg to mention item number 27.
Item
27. For the day.
Okay, your name?
K. is Mullah on behalf of
K.
A. Dewan. K. is Mullah on behalf of A. Dewan.
On behalf of Mr. A. Dewan. Okay. After 2 weeks.
After 2 weeks.
Okay. 27.
I beg to mention item number 28 and 30.
28 and 30.
Yes, Lord.
Okay, after 2 weeks. Your name?
R.I. Mandal on behalf of M. Hussain.
R.N.
R.I. Mandal.
R.I. Mandal, on behalf of Mr. M. Hussain,
M. Hussain.
counsel for the petitioner. Okay.
I declaration item number 33, Lordship.
33.
Can it be possible for the day, Lordship?
It goes for a week.
Lordship?
Okay, Mr. Item 33, and prayer made by Mr. R. Fukan, counsel for the petitioner.
Okay.
It will be inspected, what's this?
What the, if they want to see, they'll see, why should we? They have not seen, that is their problem. And orders matter, you can, I will have matter on someone. You want to be called up all matters or? The I matters.
Item 42. 42. 42.
42.
Upgraded item 42. IA 344/23.
Yes, what has happened thereafter?
My lord, petitioner could not able to appear before the.
After 10-5, what has happened?
Lordship. This is Lordship. Halima Khatun, Lordship. Halima Khatun, Lordship, it was Lordship. Read petition was dismissed, Lordship. Originally, it was a ex parte order, Lordship. After that, appeal was filed before this honorable court.
Yes.
Then Lordship, without considering on merit, Lordship, proceeded. This honorable court, Lordship, allowed the petition
With a cost
by
of
imposing
1,000,
some cost,
10,000,
Lordship.
yes.
Yes, Lordship. Imposing some cost, Lordship, and when proceeded approached before the tribunal, Lordship, after imposing cost, Lordship, then he came to learn that before the tribunal, Lordship, that record was not available, Lordship.
Yes.
Yes, Lordship. After that, Lordship, he again approached this honorable court by filing this IA, Lordship.
But, Mr. Sharma, you have to tell us your stand. What is the stand of the government in this regard? Their case is that the records are missing,
Yes, Lordship.
and therefore, when the matter was sent back, it would not proceed. So they are asking for the petitioner is asking for a de novo reference.
Proceeding.
So what is your stand in the government in this regard? Because in this case, you will have to file an affidavit.
Lordship.
because of two reasons. Number one, with regard to the nature of prayer made. And second, they are saying that the records are missing.
Yes, Lordship.
So for that, although we have your letter, but we need an affidavit.
I have communicated to the department, Lordship.
Yeah.
And department also, Lordship, not able to.
No, that
Yes,
is okay
okay.
because you see, what is happening is, we have a copy of your letter of 10/6.
Yes, Lordship.
Now this says that the records were communicated to the junior government advocate.
Yes, Lordship.
But we don't know how the records would go to the government advocate. It should
Yes.
normally be, it's called by the court and has to come to court.
Yes.
So how this matter was transmitted to government advocate, we don't know. So we'll need an affidavit to set the matter right. Because if the records are missing, there has to be an affidavit of the state government. Because there's, so far as you see, normal civil case or a criminal case is concerned, the court has the power to ask for a reconstruction of records.
Yes.
Now, in foreigners tribunals, we don't know how, which procedure is being followed insofar as reconstruction of records are concerned. So
Lordship.
therefore, the government will have to tell us.
Lordship, for the time being, Lordship, for the time being, pass over the matter, Lordship. Lordship,
We are
I
adjourning
shall
matter,
file
you
our
take a-
affidavit, Lordship, but I require to present my senior colleague, Lordship. Lordship.
Okay.
No,
No, we adjourn the matter, you tell them, you tell them,
You instruct him to appear on some other date,
Yes, Lordship.
correct?
and you also file an affidavit
Yes.
as required.
Now, if there's a call for the petitioner. However, Mr. G. Sharma, that's standing counsel for the Home Department. Mr. M. Kulil Leonard. The counsel appearing on behalf of Mr. A.I. Ali, counsel for the ECI. And Mr. P. N. Sharma, the government advocate, are present. Mr. And as well as Mr. R.K. Talukdar and government advocate are present. Next paragraph. The nature of the prayer made this interlocutory application is recorded in the previous order dated 10/5/2024. Full stop. Taking note of the same and taking note of the submissions made by the government advocate for the Home Department, the court is inclined to direct the respondent numbers respondent with 2 and 4 to file an affidavit Home Department. Respondent number 2, only 2. To file an affidavit to bring on record their stand. Next paragraph. List after 4 weeks on a date to be fixed by the office, by the registry.
I apologize, Manoj. I appear for the petitioner in this matter, the applicant.
Okay.
I was
Your
unaware
name?
that the matter had been updated. I
Your
was
name?
on my legs in another court.
Your name?
A. Gautam Manoj.
Mr. A. Gautam, for the president present. Okay.
We are only taking up the order matters with IA because normally these matters get left out. So therefore we had called up.
Very good. I apologize, Manoj. I was on my
No,
legs. I
no,
didn't
no apology is required.
I'm grateful.
Upgraded item 44.
Yes, Mr. Hussain, what is your prayer here?
My lord, earlier the petitioner approached this honorable High Court against the ex parte order passed by judges.
What is the reason for not being able to appear?
My lord, the petitioner earlier approached this honorable court, lordship.
You are coming after delay of 1 year, 3 months.
Yes,
You have to
lordship.
give a good
My lord,
explanation.
that is due to the date of the learned counsel, lordship. The petitioner approached this honorable court through a counsel from the learned court below. The counsel from the learned court below in the meantime expired, lordship. Therefore, there was communication gap between the petitioner and this counsel before the honorable High Court. He had no direct communication with the counsel, lordship, before this honorable court.
Extend the time. Advocate has died. Mr. Sharma,
Lordship.
extend the time. The advocate has died. Okay. Mr. By heard Mr. M.I. Hussain, the counsel for the petitioner. Mr. G. Sharma, same counsel for the respondents. Next panel. By filing this interlocutory application, the applicant is seeking extension of time to appear before the Foreigners Tribunal 11th Barpeta in connection with case number within bracket B, capital B, small pt, public 11th, bracket close, FT 891 of 2016, page 1. Next paragraph. It is projected that the petitioner had no direct communication with the learned counsel engaged in WPC 4640 of 2022. And in the meanwhile, the engaged counsel of the petitioner, late Shah, SHAH, JAHAN, Shah Jahan, one word, Ali, was engaged in connection with the proceedings before the Learned Foreigners Tribunal had expired. And due to which the order of the court was not communicated to the petitioner. For which he could not comply with the order of the court. Next paragraph. Although the learned standing counsel for the Home Department has opposed the prayer, but considering the explanation tendered, the same is accepted at good and sufficient cause for not being able to appear before the Learned Foreigners Tribunal, Barpeta 11th, within the time allowed by order dated 26/6/2023, passed in WPC 4640 of 2022. Next paragraph. We give you time till 8th of November to appear. 8th of November, you get more than 10 days. So accordingly, time is extended till 8/11/2024 for the petitioner to appear before the Learned Foreigners Tribunal 11th of Orbita in connection with the case, the case referred above. Full stop. Next paragraph. Accordingly, this order shall be read together with order dated 26/6/2023, passed by this court in WBC 4640 of 2022. Next, this interlocutory application stands allowed
Lordship,
in terms of
a cost was imposed, Lordship, on earlier order, Lordship. So during appearance, Lordship, proceeding.
we have said this order will, we have not modified this order. We are saying that this order will be read along with that.
Yes.
So those conditions will apply.
We're only extending the time.
Time, only that much. The extent as indicated above.
45.
Lordship, this application was filed in Saga petition for releasing him from the custody matter, who was taken into custody matter on 2/9/2024. And ex parte order has been filed without issuing, without serving any notice, my lord. And the order has been
21,
lost,
let
my
us
lord,
see
against
the,
one Azmat Ali, my lord. I am Azmal Haq.
I don't record to.
As you are already received, my lord. Nameplate. I have to sound. I have to. I have to vision that. That will be. Just in the.
Yeah, it is 20 degrees. So, one it is to be a second.
Mhm. জন্য বিচারি গাঁৱৰ গৈ মানুহৰ জন্য লগ পাই
Yes,
the
sir.
records.
Record I have not gone through, Lordship, but from order I had seen, Lordship. A father's name is similar, Lordship.
No, first thing is that there is no decision of the tribunal,
Yes,
the
yes,
next
sir.
party. Notice was not served.
Yes.
So if you want, you can go through to satisfy yourself.
No, Lordship may remand him, Lordship, he has to prove before the tribunal that both these persons are two different persons.
Next party. We first have to
Mm.
set the order, then he will prove what is.
Yes, Lordship. Yes, Lordship.
Because the Justice Service report says that such person is not there.
Yes.
Nomura gives a certificate that such person is not there. And this has come before the court giving the same address. Is there in the bill?
Name is different, my lord. My name is Azmal Haq and the proceeding here, Azmat Ali. That is different. That is why
Then you're not the proceeding.
I am not the proceeding, but as
Bond father's name is similar, lordship.
What is your name?
Azmal Haq. And the proceeding is Azmat Ali. But in persons of this order, my lord, I have taken into custody.
Then we'll have to hear the matter because the order is against Azmot Ali.
Not sure. But I have taken into custody, my lord, in persons of this order.
So you have been taken into custody, but
My father is similar, that is why, my lord. The village is same, my lord.
Mr. Sharma, you was thinking aloud of forming an open team.
Lordship.
Can your this border make an inquiry and tell us within a week whether this alien Fox or same person or not?
Lordship. Yes, lordship.
2 weeks. 2 weeks. An inquiry first.
Okay.
Hey, Mubarak, Lanet Park. Applicant. Also heard. But not aware. Can you proceed for the home department?
And maybe on behalf of the.
Getting on behalf of I. And Mr. Directed English. Oh. Proceeding. In FT case number 33, within bracket. The 19. I think not over the 9-1 of level 1. Because it's party. By opinion dated 25/2/2021. Passed by the Senate Parliament agreement. First one, that's one. Please. Whose name is Azman 8KMAL. Has been detained. Pursuant to the said opinion. And is now at
Matia, my lord. Golpati.
Welcome. Welcome. Will be projected that This process was. Ali was returned answer. The resident of same village. There is similarity in the father's name. What is the intent to direct spend of police within get it? Set up.
Was it inquiry? Just to the
Inquiry. For the
petition,
again,
same person.
what has to the applicant. As per. Oh, FT case number 33, we look at the Roman 3. Using out of reference number 391. This one. 11.
Yes. Yes, Lordship. 811.
Here. It is interrogate the applications.
Supply item 46 for orders.
time long will be.
Copy of the order.
May I please your lordship? Lordship, we have filed an AI for condonation of delay for filing a writ appeal. Lordship, there has been a delay of 1224 days from the date of expiry of period of limitation. Lordship, however, out of those 1224 days, 923 days were spent in the adjudication of a review petition, which was filed on 17/3/2021, and the same was dismissed on
154 days.
You'll have to issue notice, sir. First day.
4 days. Out of which 923 days.
were spent in the adjudication of a review petition, Lordship.
And for other period, what is your explanation?
Lordship, since there is financial straits in the family, in the family, so it took them some time to gather capital and approach the court.
Each one notice them.
Yes.
Learned counsel for the petitioner. Rules for the respondent, Mr. Sharma,
Yes,
for all.
not one. Only one,
You're appearing for two,
yes, madam, two, 2, 3.
2, 3, 4, 5.
Four
Six.
BTA, four BTAD minor. Five, 6.
2, 3, 5, and 6. Steps on respondent number 1 and 4 within 1 week from today. Since Mr. Sharma has entered appearances on behalf of respondent 2, 3, 5, and 6, notices are waived. However, extra copies be furnished within 1 week from today. Respondents are at liberty to file their objections. Matter be listed after 4 weeks.
Wait, Lordship.
Item 48.
May I plead the lordship?
Restoration. Interim order. You want extension?
My lord.
What is your explanation?
I have explained at para 4.
Flood.
That due to heavy rain and flood. And moreover, the petitioner has no contact number and she could not able to contact with the engaged lawyer. And she was informed only on 26/24
How?
from one of his villagers, co-villagers.
How will the villager come to know? Hmm? Hmm. The explanation was good. Yes, Mr. Sharma.
Lordship. No.
Come within reasonable time.
Yes, Lordship.
Please come within a reasonable time.
Mr. P.A. Ahmed, learned counsel for the petitioner, Mr. G. Sharma, appearing for the respondents number 3, 5, 6, 8, 9, and 11. Mr. Puli appears for respondent number 2. Who's for the union? CGSC, are there any? Oh, Mr. P.K. Medi appears for the respondent number 1. And Mr. P. Sharma appears for respondent number 7, 7, and 10. Huh? Mr. Talukdar for 10. Huh? 1 for 7 and 1 for 10. Yes. All right. This application has been filed with the petitioner, praying for extension of time to comply with the order dated 29/5/2024, passed by the coordinate bench in WPC 8826 of 2018. Stop. By the order dated 29/5/2024, while issuing rule, this court was pleased to call for the records of the FT case number 328 from of 2017 from Foreigners Tribunal number 10th, Borpeta. Stop. The court was also pleased to direct the petitioner to appear before the SP border Boxa on or before 21/6/2024, and upon furnishing a bail bond was permitted to remain on bail. Stop. Further direction was issued to the SP border Boxa to record the biometrics of the iris of both the eyes and fingerprints and photographs of the petitioner, as well as necessary information and documents relating to the petitioner. Stop. Para. Learned counsel for the petitioner has submitted that the petitioner did not have a personal contact number and she could not obtain the certified copy of the order in time. Stop. She came to be informed about this order through one of her co-villagers, but she was not able to proceed to Guwahati from her place of residence, which is Borpeta, to collect the certified copy and then appear before the SP border Boxa on or before 21/6/2024 as directed by this court. Stop. It is submitted that the petitioner applicant is an illiterate woman and therefore could not make necessary correspondences in time with her engaged counsel. Stop. Learned counsel for the petitioner submits that the prayer for extension of time be accepted and the petitioner be permitted to appear before SP border Boxa within the further extended period of 7 days to comply with the directions of this court. Correct. Mr. Learned counsels appearing for the respondents do not object to the prayer made by the petitioner, by the applicant. Stop. Accordingly, his IA stands disposed of and the applicant is permitted to appear before the SP border Boxa within a period of within a further period of 7 days from today. Stop. If the petitioner appears as directed within a further period of 7 days, and furnishes a bail bond of ₹5,000, the directions contained in the order 29/5/2024 passed in WPC number so-and-so shall be carried out by the SP border Boxa. Stop. The IA accordingly stands disposed of. This order shall be read together with the order dated 29/5/2024 passed in WPC 8826 of 2018. IA accordingly stands disposed of.
And daily list item 2 or motion.
In this case, engaged counsel after board one lake matter for time being matter. Item number 2 matter. Time being. Yes, ma'am.
Right for Monday. Ready?
As your lordship.
Procedure. Here, meter.
Hello.
Item 3,
LCR has been received, my lord. LCR has been received, my lord, so let the matter fixed for hearing, my lord.
You'll have to issue notice then.
Order to
Hmm. Six. It over, I believe. Six. No, they arrived here. This card was issued in 66. The order to kill is it? Key will be. Oh, 3 years. No, no, he's challenging this order. By their own admission, they had come from there. This is a document. Why is he challenging this? You're aggrieved by which order?
Case number 22, my lord. Order dated 4/2/2014, my lord.
22.
Case 22.
Oh,
Yes, my lord.
What is the ground to challenge it?
But admitted, my lord, the petitioner was born in Bangladesh, my lord, in the district of Moymanching, my lord. But due to religious persecution, my lord, his parents, my lord, migrated from Bangladesh to India, my lord, way back in 1964, my lord. To that effect, my lord, a migration certificate has been issued, my lord, by the competent authority, my lord, which is Annexure A, my lord, page 13, including the petitioner and his
Migration may be made,
64, my lord.
but the registration is in 67.
67, my lord.
You don't find any reason to interfere with the opinion.
But they are residing in India, my lord. My lord,
no.
6A.
yes,
You are admittedly, when we accept that you came in 1960, not get yourself registered. By the time you got yourself registered.
there is no direction. my lord.
By the time you got yourself registered.
Yes.
It is 67. You fall after, from the date of registration, you fall within the 66 stream.
At the relevant time, my lord, there was no direction to register their name. Kindly see the
No,
page
registration of foreigner was
32
always a requirement.
Page 32 also, my lord, a certificate issued by the superintendent, my lord, PL Home, Bavnegao, my lord.
So show us the direction, show us the finding of the opinion of the tribunal.
Page 32, my lord. 22.
Huh?
Page 22, my lord.
The final order.
Final order is judgment at page 22, my lord. It starts from page 22. Final order, my lord, order is at page, my lord, 26, my lord. Order. In result, the respondent Satyavan Das hopelessly failed to prove his case in spite of providing reasonable opportunities. Hence, in my opinion, respondent is an illegal migrant of post 1971 history.
Or thereafter.
That is the direction.
There is some finding there. If a person managed an REC, a family migrant, and tried without obtaining registration after a long period of, we can opine, as per REC, he arrived in India in 67 or thereafter before 1971. So is this a finding or?
REC. P266 is missing.
To do for issue. Either you discard this. Begin to discard it. It will, please. Yes, I would do.
We privacy think that this matter has to be allowed.
Not so.
We are showing you this record. Thus, the registration certificate is there.
Yes.
We can't read the date of 1970 there. It is the finding at page 25. You please come to page 25. First paragraph. REC shows signature of issuing authority on 11/12/67. Correct?
Page 25 of the read petition, Lordship.
Yes, read petition. First paragraph, page 25.
Yes.
About 5-6 lines. REC shows signature of issuing authority on 11/12/67.
Yes.
Right?
Yes, yes.
Not see the original record. The evidence is there. You forget that booklet. Come to next page. Yes, left side, left hand. Huh? This page, turn over. Now, the third page, left side, entry into India. You got it? Last down below, or it is in the first page, I forgot. See the first page, entry into India. No, the pre-page. Handwritten. Then first page. No, first page, back page. First page, turn over. Entry into India. It is handwritten by pen.
Yes, yes. Date of arrival in India.
You've seen that? Please read it.
25. Something.
364.
Okay.
Correct.
Yes,
After that, there is also something written.
25, 64.
Huh.
This was not fully legible, Lordship.
No, we can read it. It is Dabu. At
Yes,
Dabu in Garo Hills district.
Yes, yes.
Correct.
Yes.
Now, how does the tribunal arrive at a finding that he has managed to get it? That means the your home ministry of the Union of India is an institution which can be managed.
Yes, Lordship. Lordship serial 8 also, Lordship. Particulars of the members of the family migrated into India before.
That is okay, but the tribunal is returning a finding.
Yes.
Is the state and the Union of India happy with it? They have managed.
Yes. No.
So this FRRO is a authority under whom? Union of India or State of Assam?
FRO is state of Assam.
State of, so you are happy with this observation?
Lordship.
The tribunal does not even have the interest in reading the documents.
Yes, yes.
Then
Lordship may remand the matter, Lordship, by.
no, you see, we find it very interesting.
Yes, Lordship.
Petitioner wants an adjournment, respondent wants an adjournment. It is only our duty to read it and find out the records. It's so frustrating.
Lordship.
You go through the records and come back on Monday.
Yes, Lordship.
Tell us.
Go through it. Because once we apply our mind, we find it very frustrating if we don't find assistance from both of you. Nobody has the interest in reading the records. Burden of section 9 is on us. We both brothers are doing the exercise. Reading and finding out. And then the bar tells us that your disposals are very low.
Sorry.
Now tell us, if we do the original work, how much matters we will be disposing of? There are 7,800 cases of foreigners lying in the registry of this court. Unless both sides resist us. Next 20 years also we don't see a disposal of these matters. How much time does it take?
You have so many standing counsel, Mr. Sharma.
Yes.
What is your strength in terms of standing counsels? How many standing counsels are there?
Lordship.
Your
Five,
department.
Yes, Lordship. 5 standing counsel.
Five standing.
How many courts are taking up foreigners matters in this court today?
Why don't you share the work and divide the work and address the court? How much time does it take?
Because one day we will pass a funny order. We'll ask your home department to change the counsel if you are not assisting us.
You should divide the matters and try and assist the court where the records are called for. The records are there. You are familiar with the records. You point out, tell us. That is the only way to go.
Because Mr. Sharma, to arrive at this, even this finding,
Yes, Lordship.
you will have to understand that we have read some part of the order,
Yes, Lordship.
found out the fault, and then see the records, find out the dates of entries.
Yes.
And then ask you only one question. Because if you expect the court to read and then find out everything and then ask questions, we'll have to make these two red seats a hot seat.
We will have it on Monday.
Yes,
You go through the records and
Go through
come
the
prepared.
records. Because if you can't go through the records, please take an adjournment. But once we take up the matters, then there is no question of adjournment.
Lordship.
We won't be wasting our time.
Wednesday, my lord. Wednesday, I will contact my client also. On Wednesday, my lord.
Wednesday, okay.
Wednesday.
Both sides are represented. The learned Mr. G. Sharma standing counsel for the Home Department, plays for some time to go through the records and address the court. Next para, list on Wednesday, 23rd. Oh, sorry, 33-0.
Item 5 also, my lord. Item 5 also, my lord.
5 also same.
Yes.
Mr. Sharma, please tell us which records do you need to read?
Lordship.
Otherwise, you adjourn the matter, all the matters.
Yes.
We won't be reading the records. We want your assistance.
Okay.
So tell us the case numbers where you have not gone through the records. We'll adjourn all the matters.
One by one.
We are calling one by one. We'll pass orders. If you have not gone through the records, we'll be adjourning it. This applies to the counsel for the petitioners also. Next item.
Item 4,
My lord, Mr. Kayyum requested me for time being, my lord. So Kayyum was there.
Time being.
Yes, my lord.
Okay. Time being.
item 6,
Wait, please, your lord. My lord, in this case, record was called for, my lord. No notice was also issued, my lord. So I pray, my lord, lordship may issue notice and fix it for hearing,
Sir, you have gone through the record, you address us.
my lord. So any other day, my lord. I'll get it. Interim order may be continued. my lord. Obliged.
item 7, item 5 is normally.
MK Sharma, H dash. The names are reflected. This order will have to be communicated to the writ petitioner. দিছে নেকি তো?
Resolution from the. Next one. Sir, he shall not done it. He done it. Yeah, yeah. Can you come in and get out of it? In that. 2019. Of. This is the petition. Taken back by. WAGX. Ali. Some of the petition. Thereafter, the order dated 57/2000. Court had recorded the same. The matter was adjourned, enable the petitioner to engage in more. The registry was directed not to reflect the name. For the petition. Tested to person.
Fellow is under detention. This fellow is under detention. Maybe we have to, or we'll have to get the instruction whether he's still under detention. In detention. Arrested on 2015. Presently under detention. Go to wishing. Detention not asking my really detention not asking. Then. My customer was. After dismissal detention, what a better put. Then we find that he's already under detention. I think we should. And at least primarily see whether. Status of his detention.
Else, it is not. It's the detention. Connect. On the party, well, any information. It will be fixed. This doctor.
Well, they can information whether. Status of his detention. Oh, 3 weeks.
After 3 weeks. Very rest.
Time being item 4.
Lordship. For the time being, Lordship, I want to see the record, Lordship. For the time being.
Item 8.
Lordship, hearing today. I'm totally unwell for last 3 days, Lordship. I'm not in a position to do the hearing. So can it be taken up either on Friday, day after tomorrow, or maybe on Monday? Somehow I have come for 1 hour today. Last 2 days I was not present also in the court.
Yes.
Please, my lord, if it can be taken on Monday.
Yeah, if it is subject to your lordship, the other council.
What your lordship says.
Also is a representative. All sides are represented. Just say all sides, including Mr. C. Gonzalez, learned senior counsel. So all sides are represented. Mr. C. Gonzalez, learned senior counsel, appears through video conferencing. Next paragraph. Mr. D. Saikia, learned advocate general, has submitted that he is unwell and prays for an adjournment. Next paragraph. Prayer is allowed. List on. Give a date on Monday, 28/10/2024.
Deeply obliged, Lordship.
Grateful.
Item 9.
May I plead the Lordship, my lord,
From health to coroner.
yes, my lord. My lord, the opinion is at page 54, my lord.
54.
Yes, my lord.
What is the best document with which you are connecting with your father or grandfather?
My lord, Annexure 5 at page 32, the voter list of 1966. Then page 32, my lord, your lordship will find at page 32, my lord.
Look, to connect with your father or grandfather, you'll have to have a document other than.
Yes, my lord. In page 32, my lord, the voter list of 1960, my lord, the name of the father of the petitioner appears, my lord.
Yes.
Then, my lord, in voter list of 1970, also the name of the father of the petitioner appears. Then, my lord, in the voter list of 1985, my lord, the name of the petitioner along with his father appears, my lord.
We issue notice, then call for the records.
Yes.
And my lord, the petitioner has been taken into custody, my lord. So he may be released, my lord.
Always don't know the records. I think we will require a hearing.
Will not be deported.
Will be deported. See the reports.
Opinion was passed in year 2018, Lordship. Lordship, notice may be issued, Lordship. This Lordship. Miss case also.
You are taken into custody when?
On 7/8/2024, my lord.
Then what is the explanation?
Explanation, my lord, although it is not, my lord, there is no record because we are told that, my lord, immediately after passing of the judgment, they contacted with someone and they were of the impression that the case has been filed, my lord, but it was not filed.
Then
But otherwise, prima facie, my lord, if
No,
you.
that's okay. Then, Mr. Bora, we are just saying that you will not be deported.
Yes, my
We
lord.
take up the prayer for bail when the records are received. We'll
Yes, sir.
need
That
some.
observation may be kindly recorded, but because he is an old person and otherwise, my lord, materials, some discrepancy regarding the name and age, my lord. Otherwise,
That's
my,
okay. We'll examine it when
Yes,
we
my
see
lord,
the
yes, my lord.
records.
That observation may be made, my lord, after receipt of the record, my lord.
For Mr. D.P. Bora, learned counsel for the petitioner. Respondents' names are there. Mr. Sharma, Mr. Kuli, and Mr. Sharma. Next, brother. The opinion dated 30/8/2018, passed by the learned member, Foreigners Tribunal number 10th, Borpeta. In FT case number 418 of 2016, arising out of IMDT D's within bracket, IMDT case number 9796 of 1998 is essayed in this writ petition filed under Article 226 of the Constitution of India. We issue notice returnable on, give a date after 4 weeks on so and so. Requisite extra copies of the writ petition be served on the learned state and department counsel within 2 days. Next, let the records of FT case number 418 of 2016 be requisitioned from the concerned tribunal. Next paragraph. The prayer for bail shall be considered on the on receipt of the records from the tribunal. Next paragraph. In the meanwhile, if the petitioner is petitioner Raham Ali alias Rahamuddin, if not already reported, shall not be deported. Next paragraph. List on 25/11.
Obliged, my lord.
Prayer for bail in the interlocutory application. Prayer for bail in the interlocutory application shall be considered on the state. We'll take a break and come back. Yes.
Yes, please, Your Lordship. Then in the instant case, the petitioner was declared foreigner, by FT case number 6, 2018, by the landed.
Just a moment.
Barpeta.
Just a moment.
Your Lordship, today was on last.
The records have not come. You have to wait for the records.
Yes.
You wanted to say something?
No, Your Lordship.
Okay. Also, is it duly represent?
Should- Till the records have come, the petitioner may be grant protection.
Okay, your name?
S.J. Hayat. S.J. Hayat.
The counsel for the petitioner. Also had Mr. G. Sharma, standing counsel for the Home Department. M. Bedi, learned
On behalf-
counsel appearing on behalf of Ms. T. Barwa, standing counsel for the Election Commission of India. And Mr. P. Sharma, learned government advocate appearing for the respondent number 4. The
Order
office
was-
note dated 21/10/2024 indicates that LCR has not yet been received. Stop. The registry will send a reminder for the records. In terms of order dated 16/9/2024. Next para. The learned counsel for the petitioner prays for interim protection to the petitioner, which is opposed by the learned standing counsel for the Home Department. Next paragraph. In the interim, the court is grant bail is 5,000 to the satisfaction of bail to the satisfaction of
SP border board.
SP border Borpeta. Okay, with this condition, iris and all everything. Next para. List on. List up to 4 weeks on a date to be fixed by the registry.
11.
May please the Lordship. Here in this case, my lord, by previous order, record was called for, record also received. My lord, record, in the record, I have seen, my lord, in page 22, the order whereby my lord, page 19, order, impugn order dated 6/9/24. Evidence was closed, where which has been challenged in the writ petition, my lord, page 59 in our writ petition. Evidence is closed. And our prayer is for taking steps for authentication of the voter list that has been rejected by the impugn order at page 59.
When did you file the petition? What is the date of filing of the petition?
My lord, petition was filed on 12/8/2024. That is
12/8/22.
12/8/24, my lord. That is in record, lordship will find in record, it is 2/21. 2/21, my lord, in the record. My petition. 12/8/2024. But order at page 19.
Where is the opinion?
My lord, opinion in record, order, my lord, at page 19 of the record, my lord, page
No,
19 of
here
the
in
record.
the writ petition,
My lord, in the read petition, we have annexed as annexer 14, lordship will find at page 59, 11%.
what is the exhibit 2, 3, and 5?
No. Exhibit,
Mhm. There's no doubt about the offense.
No, but
No doubt.
why you're not. Work it out.
Yes, I
Respondent will.
Yes, Mr. Sharma,
Lordship.
this order is practically not sustainable. You want to fill the what?
Yes, yes, lordship.
Like. This is the order by virtue of which the prayer for calling for the records was rejected, and the tribunal held that the documents are not doubted. There is no doubt about the documents. So in the opinion, the correctness of the documents was doubted. Then the second point is, Mr. Payang, the second point is, if there is no doubt of a document and you reject the application for calling for the witness to prove the certified copies, number one, certified copy is not required to be proved. Second thing is that if you don't doubt it, then what was the idea of the tribunal to write in the order? You come to page 54 of the writ petition. No, 54 of the writ petition. Opinion.
Yes,
There is, in the end, they will find there.
my lord.
Opinion is there.
Annexer 12, page 11%, page 50.
Yes, there is the opinion. No, opinion is somewhere, page 1920 or somewhere.
That will be finding the read petition. Yes, read petition or problem. Can I get it? No, it will record of night to be like
Page 54, come to paragraph 5. Exhibit 2, 3, and 5 pertaining to OP's grandfather could not be verified from the government portal. Now, if there is no doubt about a document, as per the earlier judicial order, what prompted the tribunal to look at the government to the portal? That means you have a doubt. You are verifying it from the government portal.
This is in some other case, probably.
Huh?
Case. Maybe
This is
some
in some other
some
case,
other
not in
case,
this case.
but that is the way of functioning.
This opinion is in some other case, not in this case.
Is agreed by the last order.
In some other case that we have cited as an example that you were disbelieving everything on for failure of proving the case
This
and
the page number
Not in this
59,
case, madam.
the order passed in their case. Where
It's giving as an example only. This is.
there is no doubt. But you said before this court, having met the grounds, let us see the similar matter, this is how the court is done. Now, what is the basis for the appeals? It may not happen in his case. Maybe it is premature. Matter is still pending. If there is some.
Opinion generation. Opinion.
Opinion is setting the opinion. No, no, it took one is setting the opinion. Opinion দিলে তো দিলেই নেই হলো।
যদি passes
ইমান দেরি হয়েছে আর অলপ দিলে একদিন সময় দিলে
order also.
2017 গেছে
His prayer for further thing has been rejected. So it will grant it. So they don't.
Okay, there was some
my lord my case is that
mistake in the appreciation. Mrs. Pang, then the question will change. Now, whether you support this order or not.
My lord, your lordship may
Page
direct.
59.
Yes, your lordship may remand this matter, my lord. Let them go of their case, my lord, whatever they have. But if they want to adduce evidence, let them.
that is our minimum prayer, my lord.
So only date may be given, my lord,
documents may
within,
to
otherwise it may delay.
Huh?
Only delay, they may not delay the process, my lord. Then you,
My lord,
within, my lord,
our grievance
stipulated
is-
time, your lordship may direct them to adduce evidence, whatever evidence they may have.
my lord, two certificates from NXF 10 and 11.
Because Mr. Payang, to pass that order, we'll have to record your concession that yes, you do not contest this prayer.
Yes, so I have.
Okay. And Mr. Sigdel,
My lord.
you are referring to this earlier order. We thought that this is in your case, page 48 order. Now, in this case, page 48, sorry, page 47.
Yes, my lord, it
This
is
order-
another case of the same tribunal.
No, that's okay. But in this case, where is the order of closing of the evidence? If you say similar,
My lord,
there must be a previous order saying that the what you call the evidence, there is no doubt. Where is that order?
my lord, in our case.
No,
they are
not in
saying
your
no
case.
doubt, but
In this
here,
page 47,
my lord, page 47.
where is the similar order? Where is the similar order that the evidence was closed because there is no doubt on a
my lord,
document?
No, Sasu.
Now then this will be premature.
My lord,
then your present writ petition would be
My lord.
premature.
my lord, in my case, my lord, how that can be, my lord, premature, my lord. They are rejecting my prayer, my lord,
No,
to
they are-
adduce evidence, my lord, to prove
No,
the documents,
but the court says that there is no doubt of the documents.
my lord.
So by, that means you, if there is no doubt, then why do you have to prove it? The court says that there is no doubt.
My lord, to prove the documents, it is also our satisfaction because we will be victim. So, my lord, now the tribunal is saying that no doubt, but there are so many cases for not proving the documents.
No, that is separate. You see, facts will change when there is the order. In your case, you are showing an order by which the tribunal has recorded its satisfaction that there is no doubt.
My lord,
No, why would
My
that
lord,
order be under challenge?
my lord, we are, my lord, our prayer is that the documents to be proved and the evidence is also closed without giving me, my lord, opportunity to prove, my lord, the school certificate and the Kabra certificate. These two documents are also to be proved, my lord. The learned tribunal has closed the evidence. We are also agreed by this order, my lord.
Which order?
My lord, the impugned order, my lord, page 59, the evidence is closed. We are to examine the, my lord, the Gabura and the school headmaster, my lord, to prove my documents at annexer 10 and 11. That has been, my lord, has been closed, my lord.
No, but where is your prayer?
My lord, in writ petition, we have prayed, my lord.
No, not in writ petition. You must make a prayer before the tribunal.
My lord, we have made a oral submission before the tribunal. The evidence may not be closed because we have to examine these two documents also. And our petition is specifically mentioned for the proving the voter list. But the Gabura certificate and the school certificate has not been
you see,
mentioned.
what is
That
not
is there,
before
my
the, Mr. Sikdar, what is not before the tribunal, we cannot add.
Yes.
We cannot put words which are not there before the tribunal. You have questioned the, you are taking, you are intent to take steps for authentication report on the voters list of 66, 70,
Yes,
85,
that is our main prayer, my lord.
89, so and so.
Yes, that is
In
our
this
main
regard,
prayer.
the tribunal says there is no doubt. So if there is no doubt, why is there a requirement to prove it?
My lord, tribunal has passed similar order, many
No,
cases
we are
for
repeating
failure
it.
to prove the documents.
We
They
are,
have declared.
repeating it for
But
the third time. You see, in a similar case, you'll have to show similar circumstances. That in case one, the evidence was closed without, by expression of, by making an expression that there is no doubt. And then the undoubted document was rejected. That will be same circumstances.
My lord, those documents may not be possible at this stage, my lord. We are not having that. Those documents.
So
But
therefore,
we are what prejudice will cause to the state, my lord, if I
no, it's not a question.
if
You
that
see, we
step
are
is taken, my
no.
lord.
An order of the tribunal cannot be interfered merely because we take a certain opinion. We'll have to examine the record of the order of the tribunal on the strength of whether the order passed by the tribunal is patently illegal. Because we don't have discretion that we substitute the order of the tribunal with our wisdom. So therefore,
My lord,
we are
it's a
exercising.
citizenship issue, my lord.
I understand, but how
if-
will you be prejudiced
My
if the
lord-
tribunal passes an order that I don't doubt your document? Then what is the requirement of proving
My
it?
lord, some voter lists are not even certified copy.
But the-
Annexer 7.
No, no.
Annexer 7. This is not certified copy.
Mr. Sikdar, please read the order. Subject to correction from what we can understand is, the tribunal has held that there is no doubt as to the authenticity of these documents.
My lord,
So
same
before,
tribunal declaring foreigners for
So for
said
those
fielding my
similar
question.
cases, for those similar cases, was an order like this passed prior to the opinions passed in those cases?
that
In other words, what we want to say,
we have no such
So-
order, my
so
lord. But
therefore-
we have got this order, the annexer at page
No, no.
47.
No, that may be a case where the documents were never sought to be proved by the.
But
by
in,
the-
in our case, we have sought,
No, I
that
understand.
has not been allowed to.
Mr. Sikdar, there are, let us say there are 10 hospitals in Guwahati, correct? Today is 23rd October. In 23rd October at 10 a.m., in 8 hospitals, children are born. 7 children are male, 1 is female. Now, can you question that birth by saying in 7 hospitals, male was born, and why in 1 female is born? We don't have answers for that. In this case, in your case, there's a specific order. We do not doubt your documents. So if that documents as prayed for is not doubted, why do we alter with the opinion of the tribunal? Why do we say that the expression by the tribunal that the voters list of so and so are not doubted is incorrect and therefore set aside? We can't do that.
My lord, apparently the tribunal is declaring foreigners for not proving the documents. And
No.
same thing is, and in
Yeah.
our case, there's the tribunal saying different thing.
No, you are back to square one. If they have said differently, that means you have a good case. Why do you doubt your own case?
My lord, for our satisfaction, my lord.
No, no.
My lord, this is citizenship, my lord. So the petitioner wants to prove the documents.
What is this report of authentication that you want to place before the tribunal?
Means, my lord, the authenticity means, my lord, the
No, how?
election officer make
By way
send
of-
some documents,
by
some
way of-
officer along with the records.
By
to
way of
prove with the original. My lord.
By way of certificate, or you're calling for the officers?
My lord, the election officer will send the
No,
officer.
no, no, no.
Or along with the records.
No, Mr. Sikdar, my brother, you see, this is a trick question. My brother has asked you and you have fallen into a trap. We'll tell you why. Please read page 56. There are some questions which are trick questions. You give an answer, you get trapped. Page 56.
My lord, they may send a report of
But the
authentication.
election officer is
or
denied.
They,
No,
they
no,
also,
no.
What
Please
is it
read
that
this.
you are asking for?
You have said that voters list of so and so, but they said election officer is denied to give authentication report without seal and signature of your honorable court. That in this regard, the honorable court passes an order, gives seal signature upon the notice and allows second party to take steps to the election officer for authentication report.
yes,
So we
deny.
allow only that part, authentication report.
Yes,
But you have not made a prayer to call for the election officer with records to prove it.
my lord, my
Then-
lord, that authentication report is necessary, my lord. That is our prayer, my lord.
So we refuse your prayer to call for we will not permit you to examine the election officer with the original records.
Yes, my lord. The authentication report is sufficient. That may be, my lord. That may be considered. What is made clear in the petition, that may be, my lord. Only an authentication report.
No, authentication report. Authentication report.
Secondary evidence. That is also secondary evidence.
So tribunal will become like.
Authentication report will delete you.
Can there be an order to say?
Yeah, no.
Authentication. You can
Now,
tell them to produce.
Please come to the Representation of the People's Act. Where is the provision for the election officer to give an authentication report? It's not there.
My lord, I am not.
You see, what happens is that in the foreigners tribunal, when the election officers are called, are summoned, instead of coming, they say that this is the true copy of the voters list, and they send a photocopy. And that is accepted. But that again is a secondary evidence. That's not a primary evidence within the meaning of section 62 of the Evidence Act. So if we allow you to only get the authentication report, that power must be entrusted to the Election Commission of India or its subordinate officers to issue authentication report. That is not done because for a voters list, you get a certified copy.
No, my lord, there are some copies which are not certified copy. Some copies are not certified.
certified copy. Do you have such system that you don't have certified copies? No, it can't be. It can't be accepted. This is a proposition, legal proposition, it can't be accepted. Their certified copies are not available to be given to you.
It is not
Because that will be dereliction of the power enjoined under the Representation of the People's Act. You get a certified copy, you get it.
No, not all are not certified copies. There are some copies which are not certified.
Let him apply, your lordship.
Did you apply and you do not get it?
My lord, the representation goes to show that, my lord, they have
No.
they have sought for authentication
No,
report
you
that was
see-
denied.
Definitely. Now, if you come to me today evening and say that your order, please you will have to give me a true copy of the order. I don't give. It will be my court master who will be giving it to you. So your prayer will be rejected. Let us say for this order we are passing today, you come to my chambers and ask for a true copy of the order. I'll refuse to give it to you because this is something it's not, we are not empowered to give true copy of the order because you get certified copies of the order. If you want a true copy, then my court master authenticates it and gives it to you. And for that, we always pass an order that let a true copy of the order be provided to the parties. Because otherwise, this would be an illegal copy which is being given by the court master. Every order, true copy he cannot give unless there is a direction of the court. So under the Representation of the People's Act, there is no provision whatsoever to give a authentication of a document. It's not there. I can assure you. You can take this Representation of the People's Act.
Well, that may be, my lord. There are so many cases, my lord, for want of authentication.
We are not on general. We are on specific.
Hmm.
In the Representation of the People's Act, there is no such provision.
My lord, there are some voter lists which are not certified copy. Those are
No, that is your issue. That is your problem. But what can't be given cannot be ordered. Authentication report, we can't give a judicial order to give it because certified copies are available.
My lord, all are not certified copy.
No, you don't have certified copy. Does not mean that the department is not issuing you a certified copy. There are difference in two statements.
You have to apply.
You have to apply.
My lord, we will apply, my lord. My lord, in the meantime, my lord, some time may be given, my lord. The tribunal will be directed not to
Again, we are again square one.
My lord. My
The
lord,
tribunal says we don't
this
need.
litigant, my lord, this litigant,
The tribunal-
litigants, they are approaching this.
No, you are creating a litigation.
Not for any fun, my lord.
You are creating a litigation, Mr.
My lord.
Siddhar, in this case. Tribunal says I don't doubt your document. And then you
Tribunal
come to
says,
the
my lord,
court.
same tribunal declaring
Ah,
fault as many people.
We don't understand those things.
Authentication.
General
Although
things we
the
don't.
authentication is.
Mr. Siddhar, general things we don't understand. We have very great difficulty in understanding general propositions. We want a specific instance that the tribunal accepted the documents as correct by a judicial order, and in the final opinion, it rejected. That becomes a specific example. Otherwise, I'm good in telling stories. I can tell you hundreds of stories endlessly. Specific instance that this is what has happened and this is likely to happen. If the tribunal says, I don't doubt your document, you have no reason to be here saying that we want to prove it again. Tribunal does not doubt your documents. It has given you a blank check.
And the powers ascribed on the tribunal are prescribed under this Tribunal Order 64.
Well,
Power for summoning a witness.
yes,
Because it will lead to a different precedent. Because now if we pass an order here That means it will become a law by the division bench of this court saying that the election commission has to issue a verification report. It will be an additional work. That is the difficulty. Certified copies, we understand. It is in the election branch, the deputy commissioner's office give it to you. But if you direct the election officer to do it, we are creating a provision which is not there in the Representation of the People's Act. There is no provision to give authentication report.
I leave it to Lordship.
Leave it to us, we dismiss it.
But we protect you by saying that this order will be read by the tribunal when you're passing an
My
opinion.
lord, these people are coming to the court not for fun, my lord. They're
No, did
We
we
are,
say,
we are not.
no, did we tell you? Did we, Mr. Sikdar, did we,
Sikdar, I don't think that's a submission you should make in court. As counsel of your standing.
My lord.
We are aware of
My
that.
lord, my submission is at least the voter list which are not certified copy.
Why are
They
you,
may be allowed to.
you tell us that these voters list certified copies were applied for, they were denied. You bring that statement on record. Do you have that instructions with you?
No, I have.
Then
Then-
why are you making this
My
submission?
lord, the representation goes to
you
show
know,
that.
you see, we, Mr. Sikdar, subject to what you think, both of us, we brothers think that we are in a temple of justice. We are not come here to make fun and to think that we are playing with something, or the lawyers are addressing us as if they are playing something. For us, it's a very, very onerous job to be acting in a temple of justice. So for not even for a moment, we say that you have come here for fun. If we say that, it will be derogating this institution. Therefore, we take an exception to that statement that petitioners have not come for fun. Why they have come, we don't know.
My lord, the
We-
order at Annexer 14, my lord, that is the sufficient. my
No,
lord.
no, we
At
can't
Annexer
accept
12,
it.
my lord, these same people, my lord, similarly situated persons, my lord,
Again,
or want
You
of
have failed to
verification.
produce an
The
order like
declared
this.
foreigners, my lord, same tribunal.
No, you have failed to produce an order as similar as the one passed in page 59 in respect of those matters. It is only then that you can say that those are similarly situated matters.
Step by step manner.
Was there any order as in page 59 passed in that matter? Where subsequently the tribunal turned around to say that these documents are not proof. That statement is not here.
My lord, that,
Can we proceed on a presumption in the absence of such specific pleadings?
my lord, you may be given some time to obtain instruction on that, my lord.
Because you see, if we generalize things, it will lead to a very different conclusion. We'll give you a simple example. We have a Constitution of India. One person has read the Constitution of India, he has become the President of India. Another person has read the Constitution of India, he becomes the Chief Justice of India. Another person has read the Constitution and still can't make a submission, correct submission in the court. So it's not a question of generalizing. That everybody who reads the Constitution of India gathers an experience which maybe XYZ or A, B or C would have had. So we don't generalize things. We are on specifics. There's no rule under the Representation of the People's Act or under the Act itself to get a authenticated document. So authentication is something which is not permissible. In our High Court rules, you come to the Criminal Code rules and orders, you will get a provision by which when certified copies of documents cannot be given, certified to be true documents are given. For that, we have a specific provision. A private document for which even if it is a part of the proceedings in a criminal proceeding, let us say a check, you don't get a certified copy of the check which is appended to the the complaint petition. You get a true copy. For that, we have specific provision in the Criminal Code rules and orders. So if we pass an order, then please give him a certified copy. Would it be correct? You see, A comes to court he makes an affidavit. He says that I am the President of India. And then you want to come and apply for a certified copy of that affidavit. Will it be given to you? Will the court certify and give you a copy of the affidavit, self-declaration affidavit in past filed in a criminal case saying that X is the President of India? You're not getting it. Criminal code rules and orders bar it. So therefore, similarly, you'll have to come here and tell us that under the Representative of the People's Act, there is a provision to give authenticated copies. Number two, you'll have to say that the uncertified copies were accepted by the tribunal in case one and turned around in the final opinion saying that the documents are not acceptable. So every two situations cannot be same. I gave you an example of 10 children being born today
My lord.
in 10 hospitals. So we have, I can tell you, stories can be endless. I'm
lord.
very, very good storyteller.
My lord,
So that doesn't take us anywhere.
we are very poor to understand the law, my lord. That may be the reason. But this tribunal
No. You
has
see,
declared so many people
if you are
foreigners.
if you are poor to understand law, Mr. Sikdar, don't mix those submissions which leads to a retaliation by the court. Now, please tell me, if you have no understanding in law, are you permitted to stand and argue a matter? Please don't. You see, we respect you. Don't put us to a situation where we retaliate.
This is poor understanding,
So poor understanding of law.
not lack of understanding.
So please don't push us to that aspect. We respect you and we want to continue that respect for you. Please don't make us use few words which will be derogatory. So therefore, the pass orders,
My lord,
pass orders at 2 o'clock. It's only one.
my lord,
Some very long.
my lord, my submission, my lord, apart of those documents, my lord,
In fact, my lord, what I have seen from the record-
authentication. I may be given, my lord, to prove the Gabra certificate and school certificate.
No, for that we can't exercise
That
original
is, that
jurisdiction.
I have made prayer in the writ petition.
No,
also.
we can't exercise original jurisdiction. We are in a writ petition. We are exercising jurisdiction certiorari.
My lord, we
You
have
can't-
made in a writ petition also.
No. Prayer you can make everything. There's no bar in making a prayer. But tell us, in a writ of certiorari, can we grant that prayer? We ask you a legal question. At 2 o'clock, please answer us.
My lord,
At 2
my
o'clock,
citizenship will go, my lord, if we cannot prove the school certificate.
we don't know. That's not a prayer before the tribunal which was rejected. We are told you, we are exercising jurisdiction under certiorari.
Your prayer is very
My lord,
specific.
my lord, the order, tribunal's order also recorded the closing of the evidence. If the evidence is closed, then I have no scope to urge for the proof of
But
the school certificate. my lord.
whether your application contain, in addition to what has been rejected.
That is not there. That
Then what stopped you from filing an application in the first instance to say that these 1, 2, 3, 4, 5, these are the areas where
my
I
lord,
want to make my evidence?
my grievance is also against the closing of evidence.
No, closing
If the
of-
evidence is closed, then my lord,
No,
my
evidence is closed,
everything is closed, my
because
lord.
you did not pray for it, pray for any further evidence except for those authentication report.
My lord,
Tribunal has a time limit of 6 months to conclude the process.
my lord,
You see, we'll tell you something more. I told you I can go on endlessly. Just look at another example. You give a matriculation examination where you don't succeed in one paper by 1 marks. You file a writ petition saying that there should be a re-examination of the papers for 1 mark, and then make a prayer that now please issue a direction that if I pass, I should be admitted in a college. I should be allowed to sit in the class 12 examination. Thereafter, I should be allowed to sit in the BSc, BCom, BA examination. Thereafter, MA examination. Can we grant that prayer? I can go on endlessly, Mr.
my lord,
Sikdar.
my lord, the evidence is closed, my lord.
I
cannot
understand. So if metric you pass, can we please put a direction for something more? There's only one advertisement which says Dil Mange More. I don't remember this. What is it? Dil Mange More? Huh? Pepsi. At 2:00. Heard Mr. A.R. Sikdar, learned counsel for the petitioner. Also heard Mr. J. Pang, learned standing counsel for the respondent number 2 and 4. Mr. Bedi, learned counsel appearing on behalf of Ms. P. Barwa, standing counsel for respondent number 6. Mr. H.K. Hazarika, learned government advocate, appearing for respondent number 3. And CGC is there? Nobody. Mr.
CGC.
Mr. Mehdi. Take his name. PK Mehdi, CGC for the respondent number 1. Next time. The order dated 6/9/2024 passed by the learned member, Foreigners Tribunal, Borpeta 11th, Sarvog, is assailed in this writ petition filed under Article 226 of the Constitution of India. Next para.
My lord, my friend will be there. And
Yes. Next para. Next para. The case of the petitioner is that the on receipt of notice of the proceedings, this Borpeta case number, in case number, the case number BFT within bracket 11th bracket closed, F full stop T-1006/2017. That is the case number in so and so. Case of the petitioner that on receipt of notice of the proceedings, she has appeared before the learned tribunal and has filed a written statement as well as her evidence on affidavit. Only one witness or two witnesses? How many witnesses were there?
Two witnesses. my lord.
Two witnesses.
My lord, may I clarify one thing, madam?
Affidavit evidence on affidavit as DW1 and also adduced evidence of her husband as DW2
My lord,
and certain documents were exhibited.
may I clarify one thing? My lord, what happened earlier, there was an expert order by the tribunal.
No, we are here.
Those may not be
Those
necessary.
are past.
Yes, no, yes, but
No, it's okay. It's okay. But those are past.
yes,
And full stop. Thereafter, on 12/8/2024, the petitioner had filed a petition before the learned tribunal with a prayer to accept the petition and pass an order to give seal and signature of the tribunal and allow the petitioner to take steps for authentication report of voters list of the year 1966, 1970, 1985, 1989, 1997, 2005, 2010, and 2016 for the ends of justice. Full stop. It is projected that the petitioner had approached the election office at Borpeta / North Salmara at Abhayapuri for such authentication report, which was denied. Next para. The learned tribunal, by an order dated 6/9/2024, rejected the said petition on the ground that it lacked any merit, further observing that there is no doubt as to authenticity of those documents. Full stop. Accordingly, the matter was fixed for argument. Next paragraph. The learned counsel for the petitioner has submitted that in the proceedings before the foreigners tribunal, the burden is on the petitioner to prove that she is a citizen of India, not a foreigner, and therefore the evidence tendered by the petitioner should be to her satisfaction. Full stop. It is further submitted by referring to an opinion dated. Make it next paragraph. By an opinion dated 3/10/2023, passed by the same learned tribunal in case number within bracket capital B small pt / 11th bracket closed F full stop T full stop 727/2016, page number 48. Which is a proceeding between the state versus Maimana, MAYMANA, Maimana Khatun. It is submitted that the learned tribunal had rejected the evidence in respect of exhibit relating to voters list as those documents were not proved in accordance with law. Full stop. Accordingly, it is submitted that as it is the burden of the petitioner to prove the documents, in view of the said referred opinion dated 3/10/2023, passed in another proceedings, there is every likelihood that in the present case also, the learned foreigners tribunal may take a similar view, which will cause immense prejudice to the petitioner. Full stop. It is further submitted that the state would not suffer any prejudice if authentication report is procured by the petitioner and proved in accordance with law. Next paragraph. It is further submitted that there are some other documents which are also required, documentary evidence, or sorry, exhibits, documentary exhibits which are required to be proved in accordance with law, and therefore the petitioner is aggrieved by the impugned order dated 6/9/2024, as the evidence of the petitioner was closed, and the petitioner has lost her right to call for the witnesses to prove certain exhibited documents. Next paragraph. Per contra, the learned standing counsel for the Home Department has submitted that the challenge to the impugn order dated 6/9/2024 is premature because the learned foreigners tribunal, having recorded that there is no doubt as to the authenticity of those documents, has not rejected the evidence of the petitioner on the ground that the authenticity of the documents was not proved. Next paragraph. In order to counter these submissions made by the learned counsel for the Home Department, it is submitted that the petitioner would suffer prejudice if her evidence is rejected on the ground that the documents are not proved in accordance with law. Next paragraph. We have considered the materials available in the writ petition and also considered the contents of the records received from the learned tribunal. Full stop. We have also considered the submissions made at the bar. Next paragraph. It may be mentioned that in the petition filed on 12/8/2024, the only prayer is to pass an order to give seal and signature of the court, of the tribunal, and to allow the petitioner to take steps for authentication report of the voters list referred above. Full stop. Thus, there is no prayer to call for witnesses to prove other documents. Next, insofar as the prayer to call for to allow the petitioner to take steps for authentication report of the voters list referred above, we have not been shown any provision under the Representation of the People's Act or any rules or notifications made or framed thereunder, which envisages issuance of an authentication report of the voters list. Full stop. Rather, comma, we find that a voter is entitled to a certified copy of the voters list relevant for the concerned petitioner. Full stop. Therefore, comma, by a judicial order of the court. No, as you said, therefore, comma, as the court is exercising statutory jurisdiction, comma, the court should be slow in passing an order to provide for an order providing of authentication report to the petitioner, which is not envisaged either under the Representation of the People's Act or under any rules or notifications framed thereunder. Because it is always open to the petitioner to obtain a certified copy of the concerned voters list. Full stop. In this regard, we have also considered the submissions made by the learned standing counsel for the Election Commission of India, who also submits that it is that if anyone desires a certified copy of a particular voters list, and if it relates to his or her entry in the voters list, comma, such a voters list is permissible to be issued to the concerned applicant. Next paragraph. As we take note of the fact that on a petition filed by the petitioner on 12/8/2024, the learned foreigners tribunal has passed an order on 6/9/2024 with certain observations made therein, which is already referred herein before. We have no reason to doubt that the learned tribunal would not take notice of its order dated 6/9/2024 while adjudicating the matter in rendering the opinion in the proceedings against the petitioner. Full stop. Next paragraph. Therefore, comma, if the tribunal passes an order which is contrary to the observations made in the order dated 6/9/2024, it would naturally be open to the petitioner to question the same in a manner in which the petitioner may be so advised. Full stop. Next paragraph. Here is the petitioner in hand. Next paragraph. In respect of any other prayer that the petitioner may have, it will be always open to the petitioner to take such recourse as she may be so advised. Next paragraph. It is outright law that in exercise of certiorari jurisdiction, it is not open to the writ court to substitute its view with the order passed by the learned foreigners tribunal when the order is not vitiated by any error apparent or perversity. Full stop. Next, as we have already held that authentication report of the voters list could not be demonstrated from any provisions of demonstrated by the petitioner from any provisions of the representation of the People's Act or any rules or notifications issued thereunder, framed or issued thereunder. We do not find any infirmity with the impugned order dated 6/9/2024 passed by the learned member, foreigners tribunal. What is called foreigners tribunal, Borpeta 11th.
Yes, sir.
Borpeta 11th, Sarvok. Accordingly, with the observations as made herein before, the representation stands. Closed.
My lord, may I prefer an observation that the petitioner like to examine the school headmaster.
We have merely said that you take recourse to such advice as she may be given.
Well, that observation may be
No.
because we have
No,
made a
we
prayer.
already stated, we have already made a statement that you will do as you may be so advised.
My lord. Deeply obliged, Lordship.
Next para. Let the records be. Please button up your coat first. Before addressing, button up your coat. Let the records of the tribunal be returned forthwith. Next para. The petitioner shall appear before the learned foreigners tribunal
Next date fixed.
on 14/11/2024.
Next date is fixed probably.
Where we don't.
Like in the record. Oh. Next date to fix. Next date fix also.
नहीं बता असली की रिकॉर्डिंग
Next
is
date.
fine. There may be a date fixed, my lord. I think
We have not checked. Let me check it.
Lordship had fixed a date, my lord.
It's okay. Let us first see what is. 22/10. It's already gone yesterday.
Record.
22/10.
Fix
And
it.
by producing a certified copy of this order, seek further instructions from the said learned court. Learned tribunal. Said learned tribunal.
Smile.
Yes, you wanted to say something?
May seek indulgence of this honorable court in item number 43, my lord. This matter may be taken today, my lordship. I have come from Delhi. This matter was fixed for today, my lordship, by an order on 20th September.
Yes.
Okay, we'll take it up. Just wait for some time.
Oh.
Upgraded item 47, fixed at 2 p.m.
My pleasure. My lord, I have already submitted certain citations. In this case, my lord, the petitioner was declared a foreigner of post 71. My lord. Now, so far,
What is the document to connect the petitioner with the projected father and
that
grandfather?
lordship may kindly see page 21. This is the voter list of 1965.
No, what is this is one thing, but how do you connect yourself with your projected father and
Yes.
grandfather?
That is there, my lord.
Hmm.
That is page 31 and 37.
31.
Yes. If you want, this is Jamabandi. I am Sufia Khatun. My father is Muhammad Ali. And that operative portion of the.
What is your name?
My name is Sufia Khatun. Sufia Khatun.
Sufia Khatun.
And the vernacular is page 33. Vernacular is page 33.
No, which is the entry? Which is the remark? In the remark column, which is the remark?
I'll say page 33.
33 I'm there.
Sufia Khatun, son of Muhammad Ali. Daughter of
No,
Muhammad
that is you are referring to serial number 100. We are on the remarks.
Ali. Remarks, yes.
Remark column, where is the entry? Relevant entry.
Achha, remarks.
Oh, Sufia Khatun.
That is page 35 maybe seen.
35.
35. Bottom right side. Chakravikaya Shullo Noy.
What is the date of opinion?
Date of opinion, yes, ma'am. That is delay. For that, Miller, date
What
of
is the date of opinion?
Date of opinion is Miller 6/6/18.
2018.
6/6/2018.
Yes.
So you see, this is an entry at page 35 is made on 16/9/2024.
Yes.
After the opinion.
That was collected.
No,
That was
that's,
collected later.
that is different. But it is a post opinion entry.
But
So-
school certificate is there, man.
Show us, that's why we are asking you, show us the best document you have to connect you to your projected parents or grandparents.
Yes. School certificate maybe it's in page 37.
Page 37, this goes because it carries a Ashok stamp. And what is the date of this? Page 38 is not known. Please come to the opinion. This is at page 66.
Yes.
You see, page 67, come to page 67, you will find you have only examined one Julas Ali as DW2.
Julas Ali is my brother.
That's okay. And one Omar Ali as DW3.
Yes, he is the
Now,
Gabura, local
The
Gabura.
page 38 you are showing us is a school certificate.
Yes.
It was never proved.
It is not proved, but it may be believed, my lord. As
Question of believing
No, in this
that's the
regard,
second
sir.
stage. That's the second stage.
There is no.
This is when we decide the matter. But prima facie will have to be satisfied that the tribunal.
No, because, my lord, here, Rasibushi, 2009-12 SCC, a school certificate is admissible even after examining the headmaster or the issuing authority or other authorized person. Even after it is not
Correct,
without.
we don't need a citation for that. You tell us who is the authorized person. Is a Gampura authorized by the school to depose and to exhibit the document? He has not exhibited this school document.
School document has been exhibited.
No.
That is
Mr.
exhibit.
Mahmood, when you are referring to something, we are responding to only that. So please restrain yourself to your statement. You said that authorized person. You are citing our judgment and you say that the school certificate is admissible if proved by authorized person. Now we are asking you, is the Gampura authorized by the school to exhibit the document, and whether
No,
the
Gampura-
Gampura exhibited that document?
No, Gaura has exhibited his own certificate.
So therefore, please correlate to your submission and the citation. Your citation is that the school certificate is admissible if proved by an authorized person.
Yes, that is one aspect of the case. Another aspect of the case is, dear my lord, I am satisfying your lordship on that point. The school certificate
Is exhibit
is
number?
admissible even without examining the headmaster or issuing authority.
This is exhibit number. School certificate is exhibit number.
It was submitted. That is school certificate. It may be seen, my lord, page 67.
No. Yes. Which is that certificate? Just tell us the exhibit number.
Exhibit E. Sorry.
Exhibit is a
exhibit.
Gampura
Yeah,
certificate.
Gampura certificate.
Yes.
Yes.
Yes, we are asking you.
Not there.
So, Mr. Mahmood, you are not prepared. We take it up on Friday. Be prepared. List. Also, the representative. List on 25/10/2024. As paid for by the non-counsel for the petitioner.
So the other
Now, be prepared. We are updating our matter and taking it out
Friday.
Friday.
Upgraded item 43.
If this is second round of litigation, my lord. May I please, your lordship? Before my learned friend starts, lordship, earlier I was granted time for filing objection, lordship. My lord, I drafted the objection. I sent it to Tamil Nadu. The respondent is from Tamil Nadu, lordship. And he has, after notarized, he has sent the papers, but missed the main affidavit page, lordship.
I did not get it. We did not get it. Please repeat again.
Lordship, the respondent is from
In
Tamil
Tamil Nadu, I understand.
Yes, lordship, after notarized, he has sent the papers, lordship. But he has missed the main page affidavit, the notarized last page, lordship. Other pages are sent, lordship. Therefore, we could not file the affidavit.
Just first slide. We are not getting it. Maintenance. But this petition would not be maintainable as a criminal writ petition.
Yes.
This is a order challenging the This is a writ petition challenging the order of family court.
Kindly see the order of the Honorable Supreme.
No, it may be wrong. It may be 100% wrong. Everything in the order from line 1 to line 10 would be wrong.
Yes, ma'am.
But does it make
This petition has been filed under Article 227, my lord.
Can that be done? It's an application under maintenance.
Maintenance.
Maintenance 125.
125.
So under 125, you challenge the order in writ petition.
My lordship, 125, it was challenged by way of criminal revision petition, my lordship. The Honorable Court has held that the criminal revision petition is not maintainable against the interlocutory order. I went against that order before the Honorable Supreme Court, lordship. Supreme Court has given liberty that you go under Article 227. So it is not maintainable, but it is maintainable under Article 227.
Where is that order? Show us that order.
11111, my lord.
111.
Yes, my lord. The Honorable Court was of view that
Let us see 111.
it's an additional affidavit, my lordship, filed, my lord, along with I have enclosed. Yes, Milo.
You could say.
So keeping in view the different high courts have the view that it is maintainable, but doctrine of binding precedent.
Not being an interlocutory. No, but this is a revision petition. But whatever it is under the nomenclature of a revision petition. Here, the bar is on the appeal. It is not an appeal. Against interlocutor. They have dismissed their SLP, but they have said you go and explore. Uh, we'll examine it. Let us examine this matter.
My lord, within, it has to go again within 3 weeks, lordship. It has to 3 weeks, lordship.
What,
It
3
has to digital.
Document will come in 3 days. Studied by repeated couriers.
Yes, lordship. In 2 weeks may be done,
Two
lordship.
months have been given, my lordship. 19th
may be done.
August, this time was granted, my lord. It
Otherwise,
was listed on 20th, but because of non-commitment of bench, my lord.
This coming from outer state. From first going to give.
So what is supposed to come?
The affidavit, main, the affidavit part, lordship. The other portion has come, lordship.
Ah.
Lordship may kindly see, I have passed over, lordship may kindly see. The,
Where is that?
I have passed. Thank you.
There is no new document, my lordship, only the entire record of the family court. I have not taken any additional ground or new facts in this petition, my lord.
Once we are deciding it,
At what stage is the family court matter?
That
My
is,
lordship, they moved now section 9 petition before the family
91.
court.
Hmm.
When it was on evidence stage, my lordship, they are moving 91 application, sometimes 9 application, my lordship. And the petition is already on the verge of starvation, my lordship, on this meager amount. Borrowed from Bajaj Finance, my lordship. She is giving EMI 6,300 out of 10,000 this maintenance amount, my lord.
You file it within 10 days.
lordship. Lordship may kindly see, while dismissing the revision petition before this honorable high court,
Or you are filing an affidavit.
lordship, I will file a very big question.
File an affidavit. You're giving 2 weeks, no further.
Lordship.
You see, you can't take a plea. So what is the petitioner doing? What is he doing?
Now he was earlier engaged in private
Businessman company. his
Now,
own
now
company.
he is not engaged anywhere. Now he is not engaged in anywhere, lordship.
What is his qualification?
He is probably a master's lordship.
Master degree holder. Now you see, this page where you have not signed,
Yes, lordship, that is also,
there even the notice is not signed. So therefore it is casually being treated. You want to just casually send it and then take a time.
he may not be aware of judicial proceeding, lordship.
You see. If he is not aware, impose cost on him, then he will be aware. Now, where is the affidavit? It's not-
That part is missing, lordship. Therefore, I am playing, lordship.
You see, the petitioner has drafted this. He has signed all the pages except
Yes,
the
sir.
affidavit. Last page where is a prayer, it is not sign it,
Yes, lordship.
correct? And
Notary
you
report.
yourself, the counsel for the petitioner says that there are several litigations. You are filing petitions in the family courts. So you must be having some legal advice and you are doing it without any lawyer.
Lordship, may I submit one moment, lordship, for a moment, lordship. I am filing petition before the learned family court, lordship. But my learned friend, how he has dragged me to the court 7 times, only seven occasions from,
Okay, it's a
Lordship.
matrimony dispute,
Yes, lordship.
correct? In a dispute, somebody must fight, somebody must defend.
Yes, sir.
Is it anything?
I'll positively file lordship as your lordship grants time, lordship. At that time maybe granted.
Cost.
Very good. Rishi.
You went to a notary, did everything.
Notary court Rishi. Then the last page to get party. Notary getting a party. No, but his signatures ought to have been cancelled by the notary.
Signed.
Why the notary has not signed on the last page?
That is also mistake, lordship. Therefore, after receiving that, I have
No,
noticed.
It's a calculated mistake.
Yes, Lord.
It's a calculated mistake. Not even a page is signed.
Yes, Lord.
And notary has put his signature in 6 out of 7 pages. He left out 7th page.
Yes, lordship. Second.
You advise your client not to play fraud with the court, or will come down heavily.
It's a
No.
calculated mistake.
Maybe he is not aware of this.
No, no.
person. That may be.
Do you have your, what you call, do you have with you immediately now the flight expenditure? You
Yes,
have your tickets?
Yes, Milo.
Show it to us. How much amount coming and going? You deposit a photocopy of that ticket. We'll avoid that cost.
Yes, Milo.
You take out a printout somewhere and
Yes,
then
Milo.
give it to us.
Yes.
We'll avoid that amount of cost.
6,295 from Delhi to Guwahati.
No, please don't tell us. You just
Yes,
give
I
a
will
printout
provide Milo.
of the expenditure
Yes.
of coming and going.
Yes, Milo.
The
I will
flight
provide.
cost will give it.
Otherwise, lordship, respondent is paying the interim maintenance regularly, lordship. He is complying with the learned course
You
order.
have a choice, Mr. Hussain. Number one, you proceed and argue without your affidavit. Either you do it or be cost. It does not come just like that. We are not asking for his fees and all, but cost you must pay.
The notary has
Or
also
we do, or we do one thing.
exposed himself or herself to adverse orders. If the last page is not signed and the documents are not complete, why the other signatures are not cancelled? What is the meaning of this document signed by the notary, which is incomplete?
Or you can do one thing. Till your client is in a capacity to earn and give that cost, say 6,000, 6,000, 12, 13,000. Till then, you hand over all the properties to your wife as security. Very simple. Hand over that property. It's only a question of 2 weeks. Hand over all that property. Let your wife rot with the properties, and you enjoy the freedom. We have seen the description of properties mentioned in the petition. You want us to repeat it here?
I leave it to your lordship. Lordship's wisdom.
No, no.
This is not intentional.
Disclosure of the,
prior
no, you
is-
want us to disclose the properties. That is your intention, or you want to just agree to a cost?
I will leave it to your lordship's wisdom.
No,
lordship.
don't leave it,
Lordship.
because we'll throw it to the bar and we'll seek a vote as to what would be the cost. We just disclose the properties to all the members of the bar, and then we ask for a vote. Jury system will introduce in this case as an exception. No, okay, cost. Your flight ticket, you give a copy,
Yes,
photocopy of your flight
I am
ticket.
just giving below.
Huh. Your name, please?
Kapoor Bilal.
Uh, 15,000. Okay, 15,000. I go by the opinion of my brother. Heard Mr. A. Lal, learned counsel for the petitioner, and who expresses urgency in the matter and has submitted that this writ petition was filed pursuant to the order dated 4/1/2024, passed by the Supreme Court of India in in SLP within bracket criminal, CRL, stop, bracket closed, number 2935/2024. Be that as it may, Mr. M.I. Hussain, learned counsel for the petitioner, has submitted that an incomplete that he has received an unsigned written objection in the matter, but it could not be filed as it does not contain the signature of the respondent. Next. We are inclined to observe that the respondent has acted casually in sending an unsigned written objection to stop. We also express our anguish in the conduct of Mr. M. Janki, Janaki, my advocate and notary, who has attested five pages of the written objection, although it does not contain the signature of the respondent, and has left the 6th page blank, no, without signature, but affixing his notary seal. Full stop. The said notary may be well advised of how to discharge his duty as a notary, and any further instance of his lapses, the court would be compelled to direct the appropriate authorities to take note of the callous manner in which the notary has attested this 6 pages of the objection. No, 5 pages of the 5 pages of the 6-page objection, which includes an index. Full stop. In view of the unsigned objection being attested by the notary, we exercise the power to impound the said objection and make it a part of record. Next para. For ends of justice, we are inclined to adjourn the matter to give an opportunity to the respondent to file objection in an appropriate manner as he may be so advised. full stop. We extend the time to file affidavit, objection in an appropriate form within the two days, 27th. By 6/11/2024. Full stop. The learned counsel for the petitioner shall give his email address to the learned counsel for the respondent, through which advance copy of the same may be mailed to him. Next para, list on.
And also
No,
28th of
next,
November.
just next line, say. As the learned counsel for the petitioner submits that he has come from out of station to attend the proceeding, we are inclined to impose a cost of rupees 15,000 for the adjournment of the matter today, which shall be paid to the petitioner in addition to whatever interim maintenance has been granted, which is a condition precedent to hear the respondent's side on the next date of listing. Next para, list on
28th November. 28th November, 28.
28 November.
Yes.
Thursday. There's a Thursday. So you do it some Monday, Wednesday, or Friday?
Possible 29th.
29th. Okay. This one 29/11/2024.
Obliged me.
Next.
Item 12.
Okay. Yes. So the petitioner here may not first was declared Indian citizen. Then the respondent number 6, who is a private person, filed a petition before this honorable court challenging that opinion.
You have exhibited your Kabirnama.
Yes, my lord. The extract of the marriage register.
You're agreed by which order?
Agreed by the opinion. This honorable court sent the case back to the tribunal, and in the fresh proceeding, at the conclusion of the fresh proceeding, I'm declared foreigner, and I'm agreed by this opinion, and then I have preferred a review petition, which was also rejected, and I've also challenged this order.
All right. Mr. Sharma, we call for the records.
Yes.
Heard.
Most of the records, my lord, are annexed.
Learned counsel for the petitioner, Mr.
All.
O. Losker. Counsel for the petitioner, Mr. Who's for Union, P.K. Methi. Appearing for respondent 1, Mr. G. Sharma for respondent number 2, 5, 2 and 5.
Yes.
Mr. Who's for Election Commission?
AI Ali was.
AI Ali appears for respondent number 3, and Mr. Hazorika appearing for respondent number 4. So before proceeding further in the matter, this court would like to examine the records of FT case number
136.
136
Yes.
of 2011.
Yes.
Wherein the order impugned in the present writ petition being opinion dated 3/11/2023 was passed by the learned members, member Foreigners Tribunal - Roman 1, Karimganj, whereby the petitioner was declared to be a foreigner. Stop. Let the matter be listed by the registry after the records are requisitioned as directed. Stop. You are in custody.
Not mine. Interim protection may be given.
In the meantime, if the petitioner appears before the SP border Karimganj within a period of 10 days from today and furnishes a bail bond of rupees 5,000, petitioner will be allowed to remain on bail and shall not be deported out of the country without leave of this court. Stop. When the petitioner appears before the SP border, Karimganj, the biometrics of the petitioner, the biometrics of the iris of both the eyes of the petitioner and fingerprints be recorded by the SP border, Karimganj. Stop. The photograph and other particulars and details of the petitioner be also recorded by the SP border, Karimganj. Stop. Let the matter be listed again after requisition of the record. Extra copies of the writ petition be furnished to the learned standing counsels. Who is the private respondent?
The private respondent is the one who challenged the earlier opinion before this honorable court, and he also participated in the fresh proceeding, the second proceeding. So he is not necessary party, but as he has participated in the proceeding.
Let us see. We have not issued notice. Let the records come. Nine.
Mr. Shamra,
Lordship.
is there a power under the Foreigners Tribunal order
Yes, Lordship.
for a private person to participate?
Lordship, I have not understood.
No, in the Foreigners Tribunal order,
Yes, Lordship.
1964, is there a window for a private person to participate in the proceeding?
There is no
I think no such specific provision, Lordship.
And how did the tribunal entertain that? Please get information.
Yes, Lordship. Yes.
Why came before the court?
Hmm?
Why he came before the court? It was remanded. Then the final order.
The private respondent challenged the earlier opinion, 2012 opinion, and this court, after hearing on the consent of both the sides.
Why did he challenge it?
So he says that I'm not the daughter of my father. He knows my father, and my father doesn't have any daughter. That is his claim.
And you gave consent. Then we can't help it.
We'll examine.
Can't in that examine.
So I'll take steps.
No, we have not issued notice.
We have not issued notice. We only mentioned that extra copies if required, you can furnish.
Fine.
Item 13.
Okay.
Yeah, please, your lordship.
May please, your lordship. Your lordship, I have challenged the order.
You to your projected parents.
Yes, lordship. Page number 81.
Page number 81, voters list. No, apart from voters list. Voters list is not a.
Your lordship, the petitioner has been declared as foreigner of the period of 1966 and in 1966-71, lordship. The learned tribunal was of the view that, lordship, I have not annexed or exhibited any documents prior to 1966. The voter list, lordship, which I have exhibited, lordship, of 1966, that was appreciated and admitted, lordship. Lordship, may kindly come to page number 44 a moment, one paragraph.
44.
40.
Yes.
Paragraph 40, I'm reading second paragraph.
Yes.
On bare perusal of the case record, it reveals that proceeding has not submitted any document of his parents prior to the period of 1966, and the proceeding has not explained in his evidence as to why the names of his father and grandfather had not been figured in any voter list prior to the period of 1966. And therefore, Lordship, I was declared as foreigner of the 6671 history. The name of my father is very much there in the voter list 1966. Lordship. Even Lordship, if we go by section 682 Lordship of the Citizenship Act Lordship, then Lordship, I'm a citizen on the basis of that voter list. Apart from this Lordship, nothing is there in the tribunal's order Lordship.
Yes, Mr. Sharma.
Yes, notice maybe issued Lordship in this.
I think we should issue notice here.
Yes, Lordship.
Mr. M.
M.
I'm as learned counsel for the petitioner, Mr. P.K. Mehdi for Union of India. Learned CGC appearing for Union of India, Mr. G. Sharma for respondent number 2, respondent number 6 and 7. Ms. N. Bedi
And Betty.
appearing on behalf of Ms. P. Barua appears for respondent number 3. Mr. Talukdar appears for respondent number 5. This writ petition is directed against the opinion dated 8/8/24.
Yes, Lordship, page number 36.
Passed in case number B and C /FT/1465/2016. Passed by the Foreigners Tribunal Vishwanath First at Vishwanath Charili, whereby the tribunal answered the reference made against the petitioner in affirmative and held that the petitioner is a foreigner of in post 25/3/1971 street.
My lord, once
Sorry.
in between, page number 40 Lordship.
40
my lord.
1166 to 24/3/71 stream. So now you're supposed to go and register.
Lordships, if Lordship, my petition fails, then Lordship. Yeah, Lordship, section.
You are challenging this order.
Yes, Lordship, I'm challenging this order,
All right.
Lordship.
Learned counsel for the petitioner submits that this finding is not based on the evidences, proper appreciation of the evidences and materials produced by the writ petitioner. So, and being aggrieved, the present writ petition has been filed, assailing the so-and-so order. So, issue notice returnable for weeks since the respective councils represent the respondents. Notices are waived, extra copies will be furnished within 1 week from today. Registry to requisition the records relating to FT case number BNC/FT/1465 of 2016 from the Foreigners Tribunal Vishwanath First and Vishwanath. Matter be listed after receipt of the records on a date to be fixed by the registry. Extra copies where required be furnished to the respective councils. Respondent council. Registration as contemplated under the Citizenship Act, which is required to be resorted to in terms of the opinion dated so and so passed by the Foreigners Tribunal, shall be subject to the outcome of the writ petition.
Lordship, may I pray for stay of this judgment? Lordship?
No,
No, we have said
Yes, sir.
subject to the outcome. এটা দোকানে কিবা আছে মেশিন মোশন কিমান আছে কৰিলো I have to
Time being item 4.
Yes.
LCS.
Where is the order?
Page 90.
Where is the land document?
It has not been annexed because at the time they produced the before the trial court. So it may be on record. Again, they could be again.
Which year? I just wanted to get the year.
In the name of his father, brother. In the name of the brother. Exhibit F.
Yes.
Time.
2017, 10/1/2017. This is not Jamabandi Lordship.
মাটি থকাৰ প্ৰমাণ পত্ৰ This is the Your Honor.
No, this is Kabin Nama Lordship.
Kabin.
This was not proved Lordship. ইয়াৰ দ্বাৰা প্ৰমাণ পত্ৰ দিয়া হয় যে বালিজানা ৰাজহ চক্ৰৰ বালিজানা মৌজাৰ ৰামহৰিচৰৰ ২য় খণ্ড গাঁৱৰ ৬৪ নং খেৰাজ ম্যাদী এজমালি পাট্টাৰ অন্তৰ্গত তলত দিয়া ধৰণে
Land only period is not mentioned.
No.
It's just a certificate.
Brother.
Brother, no.
Not father. This in the name of the brother, but they exhibited GB certificate.
The name of the landholding certificate is in what name? Please read that name.
গিয়াসউদ্দিন পিতা হবিবুৰ ৰহমানৰ নিজৰ নামত থকা জমি হয় but when it was mutated that was not mentioned Lordship. When it was
We'll keep it for admission hearing.
Lord.
Heard Mr. D.A. Kayum, learned counsel for the petitioner, Mr. S. P.K. Medi for CGC for respondent 1, Mr. G. Sharma for respondent number 2, 3, 2 and 3. Mr. A.I. Ali for respondent number 5. And Mr. Azorita appears for respondent number 4. Nobody represents 6, National Register of Citizens.
Yes, Lordship, that instruction I have not received yet, Lordship. Yes, Lordship.
Since
within a
the
week, I shall
records,
get it, Lordship.
records of the tribunal as called for has been received. Issue notice, returnable 4 weeks since the learned standing councils have appeared. For respondents number 1, 2, 3, 4, 5, notices are waived. However, extra copies be furnished within a period of 1 week from today. Steps on respondent number 6 by registered post AD as well as usual course within 1 week from today. Matter be listed again after 4 weeks on a date to be fixed by the registry. We grant him bail, give the bail order. You appear within 10 days.
Before the SP, yes.
Before SP border?
Golpar.
Bail bond of 5,000 and biometrics, etc.
Published.
Item 14.
May I please, your lordship? Lordship, in this case, lordship, I have challenged the order dated 7/5/2024. That is at page number 64. Your lordship, in this case, lordship, the petitioner had submitted written evidence of DW 1, 2, 3, and 4 on 6/5/2023. On lordship, subsequent 3 dates, lordship, the DWs could not be examined. On 23/2/2024, lordship may kindly peruse the order dated 22/3/2024. That is at page number 62, lordship. Lordship may kindly come to page number 62. 62, my lord. 62. 23/2/2024. Today is fixed for cross-examination for the last time. The State Council is present today. The proceedee and his witness DW2 were examined today by the state. The youngest advocate for the proceedee has filed a petition by number so-and-so, dated so-and-so, praying another date for cross-examination of DW3 and 4. As the proceedee as well as DW3 and DW4 could not be able to present today before this tribunal due to their ill health. The state has no objection, prayer is allowed. Now, lordship may kindly peruse the next order.
See, the court has granted you 3 adjournments.
Yes, lordship.
Then it granted one last adjournment. Then it granted extreme last adjournment.
My lord, on 23, 2 witnesses were examined. 23, lordship, the order just now I have referred. 2 examined.
Page number?
Page number 62.
62.
Proceedee and his witness DW2 were examined today. On that day, 2 witnesses were there. They were examined. Now, my lord. Yes, lordship. On the next date, extreme last chance, lordship, on 21/3/2024. Today is fixed for cross-examination for the extreme last time. Proceedee is absent today. The State Council is absent today. Fixed for argument. Now, lordship, next date for argument was on 7/5/2024. Yes, we lordship. We did lordship. Lordship may kindly come to page number 65. 65. Why, lordship, we have missed that date, lordship? This is the petition. Only one date, lordship. And lordship, the reason, lordship may kindly allow me to just read 2 lines of the petition, lordship. It was the wrong recording in the diary of the advocate, lordship. The absence of the petitioner was simply due to wrong posting of the date in the diary of the advocate and the communication of the same to the petitioner. Since there was no fault on the part of the petitioner, hence he should not suffer for the fault of his engaged advocate. This was the petition submitted by the advocate, and thereafter, lordship, the order which I have challenged, that is page number 64, 7/5/2024 was passed.
Then what happened on 27/6?
Thereafter, lordship, on 27/6, lordship, since then, lordship, nothing is happening. No date. Nothing is happening,
It
lordship.
was fixed for opinion.
Yes, lordship. No opinion has been passed, lordship, as of now. Only one date, lordship. Lordship may even, lordship, we are ready to pay some cost, lordship. Lordship may kindly allow this petition, lordship. We will
No,
appear
no,
along
you
with the
can't allow it like that. Do you, Mr. Sharma, you should get some instructions what orders were passed on 27/6.
Yes, Lord.
Page number 64.
Yes, Lord.
7/5 was the order he is aggrieved with,
Yes, Lord.
and the next date fixed was 27/6.
Yes. I will get Lord.
These orders passed in the foreigners tribunals are not uploaded in
No.
the website or somewhere.
No, Lord.
No. Is there any access system by which a proceedee can collect the next date? That is also not there.
No.
Yeah, I agree with that.
That's right. Actually, it was uploaded. We will have seen it also. I think the extra link in the report is good enough to facilitate that.
I can't do break as an pattern. And the homework and the access to the and access.
Then to even get the government.
Positive is taken for the
You can get it by supposing research with you already. If not already.
It's not already. Mistake.
Then we are giving a stay, then we'll have to follow the record. Well, then where will stay?
Within time. Producing work. And give you the time. Subject
You are
to
suggesting that
we give an opportunity and qualify by saying if the building not already done.
we are staying.
Not saying anything. Yeah, now you did prefer. The official is very opportunity. This order will be subject to the opinion is not already passed.
Then why passing on that? Because with the information, you can take it up tomorrow
Monday.
day after.
Friday.
Friday.
Procedure has to appear in every day, Lordship, as per order 3-7, Lordship. Where it was stated that, Lordship, in case where notice is duly served, the proceeding shall appear before the foreigners tribunal in person or by counsel engaged by him or her, as the case may be, on every hearing before the foreigners tribunal. Lordship, so, Lordship.
No, you see, we were also once there
Yes,
when you were
yes,
standing.
I will get.
At times, even if with all the seriousness, at times we make mistakes in recording in the diary.
Yes,
This is a mistake I also made
yes.
when I was there. And with all sincerity, which I had, these mistakes did happen. So we don't blame. But this
Yes.
is but the only problem is that if I had made a mistake,
Yes, Lord.
I would always annex the copy of my diary, photocopy of the diary before the court to explain that this is a wrong entry made.
Lord.
That was the only thing I did. If I make a mistake, then I will annex that diary and say, authenticate the page and then give it to the court that this is what my mistake was. That is the only thing I did. Okay, but can you get it by day after tomorrow?
Yes,
The next day after tomorrow or Monday?
Next Monday.
Monday. Get us any information if any opinion is rendered.
Yes.
All sides are represented. Mr. G. Sharma, Learned, Standing Counsel for the Home Department, shall make an endeavor to inform the court as to whether any final opinion has been rendered in the proceedings of FT within FT space DC 1499 of 2016 by the Learned Foreigners Tribunal number 7th, Tejpur at Balipara. List again in the motion column on 28/10/2024. We'll be rising. Single bench.
আপনার ব্রেক দিলে নাকি হইব না ভাঙি দিলে নেক্সট ভাঙি দিলে বাকি রিমেইনিং কি হবে বাকি ভাঙি পড়ছে তুমি সামনে সিটিং মাথা ধরিলে চা খাব লাগে গলো যে আপনি যদি চা খাওয়া মাতে মই কিয় নাযাম মই হাইলিছন গলো তোর চাহ খালো